651-013, Isabel Ruff, and 659-580, 660-965, 551-313, State versus Matthew Rodriguez. Would each of you please raise your right hand? Let's see, 1, 2, 3. Deborah McGee, where are you? Wave your hand at me or something. Deborah McGee. Patty, do you see her? I don't see her.
No, sir.
Well,
Ivan?
Where's Deborah McGee, Ivan?
I'm not sure, Judge. She was on.
Oh, that's good. She's going to go to the second round. I'm sorry.
That's fine, Judge.
Manuel Escobedo, where are you? Okay, I see you. Richard Knight,
Yes, Your Honor.
where are you? Richard Knight.
Right here.
It says iPhone. You wearing a white shirt or light gray?
Yes, sir. That's
All
me.
right. Isabel Ruff,
Yeah, I had to do something.
where is Isabel Ruff?
I see her on the screen, Judge. She's not chiming in yet.
I'm here.
Okay. And Matthew Rodriguez.
Yeah, I'm here, sir.
All right. Would you each please raise your right hand? Do each of you solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth? Mr. Escobedo. You don't have to be a genius. I'm asking you if you swear to tell the truth. Manuel Escobedo. You're going to the second round also then.
Judge,
Since
he's
you cannot answer.
there. He was muted.
That's fine, but you're either gonna answer or you're not. It's real simple, folks. Go to the second round, Mr. Escobedo. Mr.
Yes.
McKnight, Mr. Richard Knight,
Yes, Your Honor.
thank you. Isabel Ruff. Isabel Ruff. Damn, okay, second round.
Isabel?
Matthew Rodriguez,
Yes, sir.
thank you. You two gentlemen, Richard Knight and Matthew Rodriguez. Before we proceed, I need to inform you that you have a constitutional right, you have constitutional rights and protections. Those are specifically including the right to remain silent, which means you don't have to make a statement, you don't have to answer questions, you don't have to submit written paperwork that has your signature, especially papers that admit or confess to wrongdoing. That's the right to remain silent. You have the right to a jury trial. That means that each of you individually has the right, with your attorney, to select 6 people from a pool of disinterested citizens who would hear the entire trial. Witnesses, whatever materials would be submitted. And those 6 people would decide whether you are not guilty or whether you've been proven guilty beyond reasonable doubt. You have the right to confront witnesses. That means each of you individually and your attorney, if you went to trial, the state would have to submit testimony to try and prove you guilty. You would have the right to question, cross-examine, or challenge any witness. That's the right to confront witnesses. You have the right to appeal. That is a right that is important. It happens after everything is over, the case is finished, but within specific time limitations and using the right forms and information, you can demand that a higher court review the official record and the evidence to answer whatever legal challenge you have. Also, each of you and the state in each case has the right to demand that the proceeding be held in the open public courtroom. That means that you could demand that we do not proceed as we're doing on the computers and stuff. It's called video conference. In order to proceed, you gentlemen have signed a document that is titled Defendant's Acknowledgement or Consent to Video Conference. Did you review and sign that, Mr. Knight?
Yes, Your Honor.
Mr. Rodriguez?
Yes, sir.
Now, you also signed other documents. These documents are all important. All of these documents that have your signature in this proceeding, did you review them with your attorney and have the advice of your attorney in signing these documents, Mr. Rodriguez
Yes, sir.
and Mr. Knight?
Yes, Your Honor.
All right. Do you have any questions about the documents that you signed, Mr. Knight,
No, Your Honor.
Mr. Rodriguez?
No, sir.
Now, one of the documents is critically important. It's titled, it identifies each of you respectively by your name, case number, or number. And the document specifically is titled Defendant's Waiver of Constitutional Rights and Court's Admonitions. The rights that I've been talking to you about are repeated and explained in written form. Hello, folks. Did you each sign those papers and understand what they said, Mr. Knight,
Yes, Your Honor.
Mr. Rodriguez?
Yes, sir.
Among the things that this document said was that the deal that you made with the state is not binding on the court, on the judge. The judge, I have the authority and responsibility to review and say yes or no to your deal. I also have the authority to punish you and within the range of punishment for the offense to which you plead. If I reject your deal, or if I give you a punishment heavier than what you agree in any form or fashion, then the law would allow you to start all over again if you choose, and nothing you've said or signed up to now would be used against you. Is that understood, Mr. Rodriguez?
Yes, sir.
Mr. Escobedo, pardon me, Mr. Knight?
Yes, Your Honor.
All right, that's all in the papers that you signed. There's another paper that I want to point out to you, wherein I, as the judge, do what's called a certification of defendant's right of appeal. Because you're doing a plea bargain, an agreement, a deal. Part of the deal is that you give up your right to appeal, as I mentioned to you earlier. Do you understand that you're giving up the right to appeal, Mr. Rodriguez?
Yes, sir.
Mr. Knight?
Yes, Your Honor.
Now, each of you apparently has applied for, or is continuing on probation. Probation is a written, legal, binding agreement between you and this court. The essence of it is that you will have to live up to 100% of the conditions of supervision that are imposed on you. And in return, there's two different things that can happen. First of all, any jail time will be suspended. Secondly, if you're applying for deferred adjudication probation, then I will not find you guilty in accordance with the agreement you're making. And other things can and will happen. So, Mr. Knight, what are we doing on that state? Is there a motion?
Yes, Your Honor.
643036.
Yes, the state's motion is to waive and abandon the extreme intoxication enhancement and proceed on a DWI first.
No objections, Your Honor.
There being no objection, the court grants that motion. Mr. Knight, your charge of extreme intoxication has been lowered to intoxication on a regular basis. That is not extreme. That lowers the punishment level. Is he getting straight probation or deferred? State?
It's gonna be straight probation, Your Honor.
All right. Mr. Knight, to the charge of DWI first. How do you plead, sir?
No contest, Your Honor.
A no contest plea in this court is considered a guilty plea and is sufficient for me to convict you. Do you understand that?
Yes, sir. Yes, sir.
Did anyone threaten you, intimidate you, or promise you anything other than the plea bargain in exchange for your plea of no contest?
No, Your Honor.
All right. I accept your plea of no contest. I find you guilty. State, well, first of all, Mr. Knight, are you a U.S. citizen?
Yes, sir.
And how do you make a living?
Right now I'm unemployed, but I plan on going back to bartending in a restaurant this coming week or the following week.
What do you normally make on a regular monthly basis as a bartender?
About $4,000, Your Honor.
Do you have children that you support?
No, Your Honor.
All right. State, what is the agreement on punishment?
Your Honor, the agreement is 180 days probated for 16 months. $500 fine plus court costs. 48 hours of community service. DWI education. Victim impact panel. TAP evaluation. And 8 months of ignition interlock.
Mr. Barrera, is that your understanding of the agreement?
It is, Your Honor.
Mr. Knight, is that your understanding of the agreement?
Yes, Your Honor. I did have one question.
I am listening.
Instead of doing the community service, is there a way I can request a donation to like Boys and Girls Club or something like that?
I will address that. Yeah, the answer to that is yes. I will address it shortly.
Okay, thank you, Your Honor.
As of right now, I accept the recommendation of the state and the agreement that's been made. I accept your plea of no contest. You are sentenced to 180 days, Bear County Jail. Suspended for 16 months. You are fined $750, which is greater than what you agreed to and puts into effect your choice whether you accept that or not. Court costs, 48 hours of community service to be performed. I'll address that shortly. The DWI education program you will complete in good faith, the victim impact panel, the TAP evaluation you will submit to, and recommendations subject to my approval. You will have 8 months continuously of ignition interlock to be installed within 30 days of today. You will appear in the offices of County Court of Law number 5 to have your thumbprints placed on the documents as required by law. Your supervisory fee will be $47 a month. Now, if you choose, you can do donation. My preference is that you donate to what's called the Gabriel Project, which can be found through the probation office at the rate of $12 an hour for each of the hours that you choose to replace and not do. Or you can donate to San Antonio Food Bank or to the Boys and Girls Club. Those are your choices. You've heard my personal preference, and that is only a personal preference and not a requirement. Do you have any questions, sir?
No, Your Honor.
Now, I have given you a punishment that's greater than what you agreed to by increasing your fine to $750. I will tell you that I am concerned that you will be working as a bartender when you have already demonstrated something of a lack of self-control on drinking. Be extra careful, Mr. Knight.
Yes, Your Honor.
I don't want to be putting you in jail for 180 days or any other time.
Me neither.
but you're putting yourself in the path of temptation. You know what you're dealing with. Be extra careful. Now, question, do you wish to accept this deal with the increase in fine, or do you want to start all over?
No, that's fine, Your Honor.
Question, Mr. Barrera, as to Mr. Knight.
No, Your Honor.
All right, Mr. Knight, do not leave this hearing until you have also met with Ms. Maricela Luna. She is the court liaison officer. She will talk to you about placing you or starting you into the probation program. The probation department, just so everyone hears this, probation is going to read to you all of the conditions of which you are bound by 100% of each condition. If you failed or refused to live up to the conditions, then the state may ask me to give you a hearing after official notice, at which time, if the evidence supports it, I can put you in jail. Is that clear?
Yes, Your Honor.
Thank you, sir. Any other questions? All right.
No, sir.
Matthew Rodriguez, you have been charged with assault, bodily injury, married. State, tell me about this.
Your Honor, this one's gonna be, on the MTR, we're going to, withdraw the motion and terminate him unsat.
Which one is that one?
That case number is 551313.
And what is the charge on that one?
That one is a possession of marijuana, 0 to 2 ounces.
All right. Is that accurate, Mr. Cuellar?
That's correct, Your Honor.
All right. The court will approve that recommendation, subject to finishing the rest of these pleas. What else do we have on Mr. Rodriguez?
And then we'll be proceeding on 659580.
Which is
And
an
that's-
assault, bodily injury, married.
Yes, Your Honor, and the state intends to TIC 660965.
All right, now. What will that be straight probation?
No, Your Honor, the offer and agreement is for deferred adjudication.
I'm sorry,
The agreement is for deferred.
deferred on an ABI family.
Yes, Your Honor.
All right. And what will be the plea will be what?
No contest is what is on the paperwork.
No contest. And what will be the conditions?
The agreement is for $300 fine plus court costs.
300,
Yes, Your Honor. 48 hours community service. BIP. No
BI
contact,
BIT, bit,
no BIP.
double T, gotcha.
No contact with Marina Garcia.
I'm
And the
sorry, I'm
state-
having trouble hearing you. No contact
Correct.
with whom?
With Marina, Marina Garcia.
Okay,
And the state would also be requesting an affirmative finding of family violence.
affirmative finding.
Yes, Your Honor, and that's the extent of the agreement.
All right. Has this individual had prior charges of this nature? Not necessarily convictions, but charges.
I would need a moment to look at his file, Your Honor.
I want you to.
Yes.
Judge, as far as in Bear County, I was able to pull that up. He does not have any previous assaults. There is a terroristic threat family household, which I'm trying to look up what that case was dismissed for insufficient evidence.
How long ago was that?
Judge, that was from 2020 as well.
All right.
And we can confirm that he doesn't have anything out of county either.
Mr. Rodriguez,
Yes, sir.
you have children you support?
Yes, sir. Child support.
How many?
One.
How old is that child?
9 years old.
And what do you do for a living?
I was working with my dad in construction, but right now I'm working at the temps.
And where?
Temp service.
You're coming across muffled to me. Say again.
Temp service, sir.
And what are you earning?
$60 to like $100 a day.
You paying child support for that one child?
Yes, sir.
Is that child related to Marina Garcia?
No, sir.
Do you live, well, you're saying pay child support. You're not living with this child?
No, sir.
Oh, you said 9 years old?
Yes, sir.
Have you ever heard the expression, a child of a abuser will be an abuser?
Well, it wasn't really like that, sir. It was
Have you ever heard that expression?
no, sir.
You might want to familiarize yourself with that. To the charge of assault, bodily injury, married. How do you plead, sir?
No contest.
A no contest plea in this court is considered a guilty plea. Now, you have applied for deferred adjudication. Let me just quickly tell you, deferred adjudication is a special kind of probation. If you live up to 100%, and I mean that very literally, Mr. Rodriguez,
Yes, sir.
if you live up to 100% of the conditions of supervision, you can benefit from the fact that this case will be dismissed and you're not convicted of the assault, bodily injury, married.
Yes, sir.
If you fail or refuse to live up to the conditions, which you're giving your word and signing your name, then the state may ask me to give you notice, bring you in for a hearing. At which time, if I believe the evidence is sufficient, I will place you under a final conviction that will follow you the rest of your life.
Yes, sir.
Are you hearing what I'm saying?
Yes, sir.
In addition, if that happens, you're looking at 100% of the range of punishment. This is a Class A, is it not, state?
It is, Your Honor.
That means, Mr. Rodriguez, that you'd be looking at a fine $0 to $4,000 and jail from 0 days to 1 year.
Yes, sir.
I want to emphasize to you, Mr. Rodriguez, that if you come in to this court and you violated the conditions on this kind of case where you've gotten a hell of a deal, which I'm not crazy about,
Yes, sir.
if the evidence substantiates it, you're not going to find me being very merciful.
Okay.
Are you hearing what I'm saying to you, sir?
Yes, sir. Yes, sir.
You better listen very carefully. I accept your plea of no contest. I find there is sufficient evidence to find you guilty, including your own plea, but I do not find you guilty. I accept with some trepidation. How's that for a good judge word? Some trepidation, the plea that's been worked out. You're fined $300 plus court costs. You will do 48 hours of community service restitution. You will submit and be a part of the BIT program, Batterers Intervention Program. You'll have no contact with Marina Garcia. That means direct or indirect. Not by phone, not by letter, not by brother, cousin, or friend. No
All right.
contact.
Sure.
There is an affirmative finding of family violence. I hope you know that, understand that that really impacts your rights of access and visiting, etc., to your own child.
Yes, sir. I know that.
What am I missing, State? That's it. Your supervisory fee will be $34 a month.
Okay.
You're not to, pardon me, you will come by the offices of County Court of Law number 5, have your thumbprint placed on the documents as required by law.
Yes,
For the
sir.
record, as part of this bargain, the court takes in consideration and dismisses case number 660965. And the motion to revoke probation is denied, but case number 551313 is terminated unsatisfactory. I have given you my best warning, Mr. Rodriguez.
Yes, sir.
We can help you, work with you, make things better for you. But we can also put you in jail and find the hell out of you.
Yes, sir.
Don't leave until you've met with Ms. Maricela Luna. She is going to start you on probation. The conditions for everybody on probation, deferred or otherwise, will be read to each of you. You will sign them and they will put a copy in your hands. So you're not going to be able to come back in here and tell me, I didn't know about that condition, Judge.
Yes, sir.
To which I will respond with a simple baloney. All right,